May I please, your lordship?
Yes,
My lord, with the consent of the respondent side, I beg to mention item number 40 and 41 of today's list. But on behalf of the appellant, my lord, we are required to file a counter affidavit, my lord, in connection with IA 2948. And I'm praying for an adjournment of 3 weeks, my lord.
who is there for the other side?
Lordship.
40 and 41.
40, 41, my lord.
Mr. R. Borpujari, learned counsel appearing for the respondents in this case, 2 weeks further time to file counter affidavit. Since the prayer is made with the consent of the other side, same stands allowed. This matter stands adjourned for 2 weeks.
Obliged.
And
These
so-
matters, 40 and 41.
Deeply obliged, my lord.
May I please, your lordship, with the consent of the other side, lordship, I beg to mention item number 26 and 27. I'm praying on behalf of Mr. D. Das, lordship. He is suffering from fever, lordship. Next week, lordship, anything.
26 and
27, lordship.
Weeks maybe allowed, ma'am.
these are
27 I-
MSc appeal.
Yes,
Lordship.
my lord, there is a delay of 2000 days. Okay, so I have to prepare due to some legal officer is not, there is 2 weeks time maybe allowed, 27.
On the request of learned counsel for the respondent made with the consent of the opposite party.
Appellant has taken time.
I can't hear anything. You come here and speak.
Appellant has taking time. So,
On the request of learned counsel for the appellant
yes,
made with the consent of the other side,
yes,
this matter stands adjourned for 2 weeks,
yes,
26, 27.
much of it.
26 and 27, lordship.
May it please, my lord. My lord, with due consent of the other side, I beg to mention item number 39, my lord.
39,
Yes, my lord.
why?
My lord, there's some difficulty on the part of the counsel engaged who is appearing on behalf of the appellant, my lord. And the appellant had filed an injunction application. The objection is also there on record. I'm seeking accommodation only for 1 day, my lord, just the day.
Expressing personal difficulty on behalf of the arguing counsel appearing for the appellant stroke applicant. A prayer for adjournment has been made for 2 weeks. Since the prayer is not opposed by the other side, same stands allowed. List the matter accordingly.
Obliged.
May I please, your lordship, with the consent of the other side, I am the petitioner claimant in item number 33 and 43.
33 and
33 and 43. Let the matter be listed after 2 weeks, your lordship.
on the request of Mr. D. Mondal, learned counsel for the respondent, 33 Diva, made with the consent of the opposite party, this matter stands adjourned for 2 weeks. A similar order in 43. But applicant, Mr. D. Mondal, learned counsel for the applicant. Yes,
Highly obliged.
May it please the lordship, I beg to mention for listing of a civil division motion on Monday, my lord. Oblige, your lordship.
May it please your lordship, with the due consent of the petitioner, I beg to mention item number 4, my lord. There's personal difficulty on the part of the counsel for the respondent, my lord.
you are appearing for whom?
Respondents. my lord.
I'm appealing for the petitioner.
Item number 4,
Yes, ma'am.
CRP.
Yes, ma'am.
On the
My
prayer
se-
of learned counsel for the respondent made with the consent of the other side, this matter stands passed over for the day.
My lord, I pray for fixing the date, my lord. If
Passed over for the day, it will come on the next motion.
yes, my
Much of it.
May I please, lordship? Lordship, I beg to mention item number 10, lordship, with the consent of the other side. This matter may pass over for the day, lordship. Next day, lordship.
You are for whom?
I am for the petitioner, lordship.
Petitioner means appellant.
Yes, lordship. Absolutely.
On the prayer of learned counsel for the appellant, this matter stands adjourned for a week. Yes,
Much obliged.
May I please, lordship, I beg to mention item number 35. Lordship, in this case, we will file a reply, lordship, to your affidavit in opposition. And next week it may be taken up.
item number 35.
35, lordship.
On the request of Ms. R. Devi, learned counsel for the applicant, made with the consent of the opposite party, this matter stands adjourned for 2 weeks. Yes.
May I be,
Obliged.
lordship. My lord, item number 12, I beg to mention, my lord, next week, my lord. Council stand, my lord, council representing is out of station, my lord.
On the request of learned
And it-
counsel
and it
for
did,
the
my lord.
appellant,
8 or
this
9.
matter stands adjourned for 10 days. Yes.
Next week, my lord.
It will come, it will come. It's been adjourned.
May I
Yes.
please,
Oblige,
lordship?
my lord.
May I please, lordship? Lordship, I beg to mention item number 50 of today's daily list.
Hmm.
Lordship, I'm on behalf of SD Purkaya sir. He is in bereavement leave, Lordship. His mother expired.
It is
Lordship,
submitted at the bar that the learned counsel for the respondent, Mr. S D Prakash, has suffered a bereavement and therefore this matter be adjourned for 2 weeks. If the prayer is not opposed, same stands allowed, fix the matter accordingly.
oh, thanks.
Interim order passed earlier to continue. Tyler Barber. Yes.
May I please, your lordship, my lord?
Yes.
In this case, my lord, I am sought to be evicted in persons with degree, my lord, and where I was not a party, my lord, in this case, my lord. In fact, the defendant that is in that suit, my lord, who is performer defendant here, my lord, he appeared and he also in his written statement stated that he has taken the room on agreement from me, my lord. As on date, my lord, I am holding the room, my lord.
No, what is your case?
Now, here, man, accordingly, I filed application man under order 21, rule 90 and 100 in the execution proceeding, my lord. In that execution proceeding, I filed. In that execution proceeding, my lord, my case, my lord, which was Miss case, my lord, that is the 56 2018, my lord, which was registered Mississippi 2018, my lord. That has been dismissed, my lord. That been dismissed, my lord. There are some lapses on my part also, my lord. I was directed to produce evidence, my lord, which a few days I did not appear, my lord. Due to serious communication with the learned counsel.
Where is the order?
My lord, that is order is page 95, my lord. Annexure 5, my lord.
Page 95.
Yes, page 95. Annexure 5, my lord. Annexure, yes, annexure K, my lord.
When was this order passed?
Yes, order was passed. Yes, order passed, my lord. 3/3/2000. Yes, 3/3/2020, my lord.
3/3/2020.
Yes, after that, I filed appeal, my lord. That appeal has been dismissed. That appeal is also under challenge, my lord. Appeal is-
Where is the order you are challenging?
Yes, sir, that is the appellate court order, my lord. That is, my lord, that is page 108, my lord. That is 26 August 2022. That has been passed, that has been passed, my lord. Appellate court upheld the titles of my lord, that judgment passed by the trial court, my lord. He has mainly discussed because I have also made a prayer to give evidence in my lord appeal, my lord.
You are the defendant.
No, my lord, I was not a party in the case, my lord. So I filed that intervenous petition, my lord, under the 21.
Mr. Chaudhary,
Yes.
give the facts to the court. What
Yes.
has happened? Who has filed the suit against whom? For what purpose?
Yes, yes, yes. My lord, here, my lord, this respondent has filed a suit for recovery and recovery from the tenancy premises, that is pro forma respondent number.
This is ejectment suit.
Yes, ejectment. So originally.
Say
that's
that
ejectment.
the suit is for ejectment.
Yes, yes.
What recovery?
Yes, my lord. Originally the suit is for ejectment suit. my lord.
Ah,
There, my lord, that has been decreed, my lord.
Hmm.
That has been decreed. I was not a party in the case. When execution case was filed, my lord, then notice came to me, my lord. Then I come to know that it is.
You were occupying the premises.
Yes, my lord.
As what? As what?
Yes, I am the occupancy premises as my lord, possessor, my lord. Yes.
In what capacity?
Yes, capacity. Because I have taken the possession. I purchased the possession from 2 persons, my lord.
Purchase possession.
Yes.
Under which law it is permissible?
No, my lord. It is admittedly a selling surplus land, my lord. Originally, it's a selling surplus land. My lord. Then whoever in possession, my lord, here, my lord, the plaintiff, the plaintiff claimed the suit that he has got the allotment from Gaon Panchayat, my lord. Accordingly, he has claimed his right, my lord. And me, my lord, after that, my lord, I purchased it from one Sifatul Nasa. That document is here, my lord. This particular plot of land, this particular premises, my lord. That is in 2005, my lord.
Show us everything.
Yes, yes, yes.
First, where is the plaint?
Yes, my lord. This plain, my lord. Your worship will find
Plaint.
yes, type copy is there, my lord. Page 21, my lord.
That was filed by the respondent against the proper. Annexure A. It was translated copy, vernacular copy is also there, my lord.
Let us see where is the prayer portion.
Yes, my lord. My lord, prayer book, page 24, my lord. Decree may be passed for eviction of the defendant being defaulter from the shop mentioned in schedule 2, my lord. 12 months. Decree may be passed for removal of belonging of defendant within time frame by the honorable court and hand over the position. Decree for recovery of area rent. There is no declaration from his side also.
This is under which provision? Ejectment, the eviction is under which, suit is under which provision?
My lord, actually, it should have been under tenancy act, my lord, actually. But I don't know under what provision they have filed, my lord. But from the plain reading of this plain, it reveals that it is a tenancy case, my lord. Since a tenancy case, it is under tenancy act, my lord. And in the written statement, your lordship kindly see, that is important, that is my case actually. Written statement, page 33, my lord.
Yes.
That is, written statement, relevant portion, page 35. The position of Asghar Ali had been notorious and continuous, openly exclusive. He died in the year 1999. His wife Sifatun Nisa is the possessory owner of the land and building thereon. Sifatun Nisa on 5/5/2004 under an unregistered deed handed over the possession of half portion of building and so and 1 kata of 10 lesser lands to Kamrul Islam. Kamrul Alam Chaudhry, that is a petitioner here, my lord. And next paragraph, my lord. The defendant at present occupying a room under agreement with Kamrul Chaudhry, the Kamrul Alam Chaudhry, my lord. I am the petitioner, my lord. But he has not been made a party in this case, my lord.
No, but unregistered deed, how it can be done?
They are, my lord, since he's a selling surplus, then, my lord, he also doing the same thing, my lord. The petitioner also, my lord. The plaintiff also, my lord. Ultimately, it is on the base of possession, actually. Because it is selling surplus, the one who is holding the position, my lord, till he is evicted lawfully.
No. When you come to the High Court,
Yes.
something
Yeah,
like that.
I understand, I understand.
You have to clearly make out a case or
Yes.
will not interfere.
Yes.
This is a High Court proceeding, not a
Yes.
Council Court proceeding.
Yes, my lord.
What is your right? You have to show the court.
Yeah, right.
How can, even if your purchase is by an unregistered deed,
Yes,
that is
I
not
believe.
valid.
Yes,
That's not valid.
yes, but kindly see, I have been in possession since 2005, my lord. My lord. That document is there, my lord. I can show, my lord. From Sifatun Nisa, this particular plot, I have purchased since 2005, my lord.
Mr. Chaudhary, this business of stalling execution proceedings must now come to an end.
No, but here, my lord, here decree has been passed without making me party, but that particular premises has been held by me, my lord. That is the.
No, held by you under what legitimate right you show us? I'll immediately stay.
Yes, I understand. But
Otherwise, I'll not stay.
yes, my lord, original land is a selling surplus that admittedly, my lord, is there. So, and I purchased the possessory, I purchased the possession from one.
You
Sifatun
cannot
Nisa.
purchase, you cannot purchase possessory right by an unregistered deed.
And since then,
cannot.
I've been holding and running my business.
Sorry?
And from whom I have purchased, and her document is also there, one settlement certificate is also.
What
there.
I am saying is,
Yes.
that era is over when merely for the asking civil court proceedings used to be stalled. This is
Yeah,
creating a massive problem for the system.
Yes, but here.
So interference will be difficult unless you
Only
you
thing,
tell
my
us.
lord, only thing, my lord, Sifatun Nisa, from whom I have purchased.
He is
some
a trespasser. How can he purchase possessory right by an unregistered deed? He is a trespasser. A trespasser cannot be protected by an order of the court. That's the law. You have to tell the court what is your right. These technicalities is not enough.
Yes, but I am holding the position, my lord, since 19.
You have to leave now. You have to vacate it.
And he has tactfully, my lord, did not make me party, my lord. Though defendant said that he is under agreement with me, my lord. And that malafide is also there. with the
That
plaintiff,
aspect
my lord.
cannot be open now unless you show what is your right. If you can show your rights, then certainly non-impingement of your client would have a fatal bearing. But what is your right? Ultimately, what will happen? Just delay it for another 5 years, 10 years.
No, absolutely not.
You
my lord.
cannot claim any right over the property.
Oh, no, only thing, my lord, my position and my document, whatever document I have, my lord, I want to produce with the court, my lord.
You do it here. We will pass an order. What is the right you have? What is your document? Show us. What you are saying?
Yes.
If that is the case, then we will not
Yes,
interfere.
that is, may not be sufficient, but here, my lord, then regarding the possessory right, my lord, my lord, your worship may allow me some time, my lord.
No, that we will, but the point is, every execution is being stalled on one ground or the other.
No, generally, my lord.
But we will not interfere unless a substantive case is made out.
Generally, my lord, the sitting surplus land, my lord, original land was belong.
Doesn't matter.
land
You
belong to tea garden, my
raise
lord.
appeal. You prefer an appeal with leave of the court. If you succeed, it's fine. But here we are only concerned with the execution proceedings.
No, but here also I have filed petition, my lord, which was dismissed, my lord, under order 21/99. Although the learned court allowed me to give evidence due to communication with the learned counsel, I have taken the ground, I could not reduce evidence, my lord.
These are all prima facie dubious tactics to obstruct a decree. The High Court will not assist.
But
this
my
one.
decree also has been obtained like this, my lord. That is very
Challenge the
unfortunate.
decree and get it set aside.
Yes,
Challenge the decree and get it set aside.
that is very unfortunate also. Because the child, kindly see, he did not file, he filed a suit for eviction. That law does not belong to him practically. If it is a government,
Even he was aware that there was a suit.
my lord.
He was also aware that there was a suit.
No, regarding this particular shop, I was not aware actually. Of my
Mr.
shop, because
Chaudhary,
there
the
are 10
simple issue is you are correct. But he is a trespasser. Even if what you are saying is accepted, he is at best a trespasser. He cannot purchase possessory right by an unregistered deed from anyone. And this defendant's husband is a tenant that he is not disputing. How can you purchase possessory right from a tenant? This will become a never-ending business. This is totally illegal.
Yes.
We cannot be
Accept this,
so narrow
yes.
and mechanical in accepting these arguments. Come up with a genuine case, a genuine right, definitely we'll examine. But this business is going on. Every time there is a execution file, somebody will come and say that I am in possession. On what basis you are in possession? If the basis is illegitimate, then we'll not interfere.
Well, yeah, general, just irrespective of this case, man. General, ceiling
This
purpose, then, my lord,
principle
the getting
will
it.
apply for everyone, even if you are on the other side.
Yes, it will happen. Generally, the ceiling surplus land, my lord, originally, my lord, belonged to a tea garden or some association. After my lord, the government used to take the land.
Mr. Chaudhary, you cannot question the title of a tenant in this subtle law. You cannot question the title of a tenant. Once your principal was determined to be a tenant,
Yes.
you cannot claim any right over the land or the building. This is not a agricultural land. There is a building on it. This is an urban area.
Yes, but here, my lord, the dependent actually, he says that he is tenant under me practically. He dependent practically in his written statement said, but he is tenant under me actually, not under the plaintiff, my lord. in his
You will
written
file a
statement.
suit, make a counterclaim. Then your title is in dispute. You have not urged that point in this proceeding.
No, but here order 21 application I have already filed. That is also.
What do you want? A final order now or after?
No, my lord,
1 week?
1 week, my lord. Let
Alright.
us see.
But the same order will come.
Yes.
On the request
oh,
of Mr. H. Chaudhary, learned
Yes.
counsel for the petitioner, this matter stands adjourned for a week.
Yes.
You examine the points, if you can satisfy this,
Yes. I
certainly
see.
will pass an order,
All right.
but not like this.
Yes. All right. my lord.
In this case, we are aggrieved by an order passed in a review petition, my lord.
Order
Well,
passed in review petition.
Yes, my lord. Review
You have
order,
challenged the order passed in review petition.
yes, my lord. What has happened is that we
Order
had,
47, rule 7.
or we had filed a, we
Take
had
it out,
filed,
order 47, rule 7.
No, it's not appealable, my lord. Order 47, rule 7 says, no, it's not appealable. So that is the reason why we
But
filed
even
it.
if it is not able, you have to challenge the original order, not the order passed in review petition.
Now, what has happened is that there's a judgment passed in our favor. There was a judgment passed in our favor. It is a decree in our favor. My lord, what has happened is some documents which were handed over to the council. He did not bring those documents on record. So after the judgment was passed, we came to know about that fact. So a review petition was filed before the learned court below. And the learned court below has held that we could not show any sufficient reason as to why the judgment has to be reviewed.
Judgment is in your favor.
Judgment is in our favor, my lord.
Then why do you want to challenge?
So what has happened is some documents which we had given to our council, he did not place those documents on record. What has happened is that we had bought a land, 2 kathas of land, and we had there was an agreement for that, and the total consideration was fixed as 6 lakhs. We had paid an amount of rupees 2 lakhs earlier. Then subsequently another 3 lakhs we had paid, but that document was not brought on record. So when we had filed a review petition, the review petition was
No, but is that a ground to file a review? Your counsel has not acted under your instruction. File a complaint against him. Why should the judgment be reviewed for that? Why should the judgment be reviewed out for that? Judgment can be reviewed if there is an error on the judgment on the part of the court. It cannot be reviewed because your lawyer has acted in an inefficient manner.
and
These businesses must stop.
those
So
documents,
how does it matter if the document is not brought? The verdict is in your favor.
but the verdict, what has happened is that the document which had given it to him, that would have had a bearing in the case, my lord. So that is the reason why we had handed over the document to him, but for reasons best known to him, that was not placed.
But then
So-
judgment cannot be reviewed on that. Order
But
47 does
Or
not-
new or subsequent facts, my lord, because that there's one ground in the review. There are 3 grounds, my lord, when we had given it to him and when we had placed that before the reviewing court, my lord. Otherwise, let this matter be sent back to the reviewing court. Let them examine it again, my lord.
Cannot be done. Civil proceedings will have to go by the CPC, not by common sense, which is the case in writ proceedings. Whether a document is placed or not, how does it matter? If the judgment is delivered, it's final. It is in your favor.
But the actual facts was not shown in the judgment. So that is the reason
File a
why.
complaint against the lawyer, then come, we'll consider.
Let it come after a week, my lord. I will seek instructions from my client.
I'll record that you are seeking time to examine whether a complaint. is
No, as regards the further proceedings, my lord.
Huh?
As regards the instructions from the client, my lord.
Mr. S. Khan, learned counsel for the petitioner submits that due to negligence of the learned counsel handling the brief before the court below, certain important documents could not be brought to the notice of the court. Full stop. Although the judgment finally went in favor of the petitioner, yet due to non-production of those vital documents, certain discrepancies have crept into the judgment and order passed by the learned trial court, which calls for a revisit. Full stop. Mr. Hound has, however, accepted in his fairness that no steps have been taken to lodge a complaint against the learned counsel for whose deficiency in service the discrepancy occurred. Full stop. Since the petitioner's counsel has prayed for how much time?
A week's time, my lord.
Same bench will remain after a week.
I'll leave it to my lord.
You would like to try in another court, obviously.
No, my lord. It's
Easier.
fine, my lord.
Huh?
I'll try over here.
Okay. Prays for a week's time to seek instruction from his client as to the seek instruction from his client on the matter. Mr. Prayer out. Is this case again after 1 week? After 1 week. Mr. Khan, this lethargy in the civil court system must end. And it is not only the duty of the court, even the lawyers.
Yes, my lord.
The civil court system has been completely condemned by the litigants. it is time that our learned councils also who are part of the system starts thinking. No decree is being executed, no order passed is sustained. Everywhere there is some problem or other. The proceedings are not perfect. And there are good councils like you who will come up with something. People are not going to the civil court. Nowadays, declaration of title is sought in writ petitions. It is time to think. Of course, if a legally sustainable case is made out, then obviously the court will interfere. But not merely for the asking. Then we'll go deep into the matter and you will have to give a legal answer. It can't go on like this. People are complaining, and being in the bench, we know what is happening. Things need to be streamlined. So be very careful and focused on what you are asking from the court. This is not about one litigation, one case, one order here or there. This is about what is the perception of the people on the civil courts. Even if you don't, we will address it.
May I please lordships? Well, here petitioner approached because the delay of the disposal of this title to 2006, my lord. What happened, my lord? The petitioner's land was, my lord, attached by the different number 1, 2, and 4. And later on, my lord, she filed the title. So later on, it was, my lord, found that this land was not same as the suit land. But thing is that, my lord, the title suit was dismissed, and then title appeal was filed, and title appeal, it is remanded back. And then again, this Honorable High Court by Sumoto CRP interfered and directed to pass the orders in 30 days. My lord, what happened, my lord? Page 57.
Petitioner to take responsibility notice upon the respondent. Yes. Notice. Not happy. You want final order today?
No, my lord, not my lord. My thing is that my only submission was that 2, 3, and 4, they are expertly already in the original court. My lord, now this again it's remanded back. They want to sell a notice to them, which is
Let them appear, then we'll see.
my lord, who.
Let them appear, you serve notice, then we'll see.
But 2, 3, and 4 has never a contest as expertly. Only one is appearing. My lord, that
You
is why
made them party here.
I have made them party.
Why
because-
have you made them party then?
My lord. That is my lord, 10, 20, 17 years I am.
Why have you made them party? You delete them?
Yes, my lord, I am.
Then you first delete, then we'll have the
So
matter.
I am at liberty to give the.
All right, Mr. Bhuma, we pass the order next time. Yes.
Wait, please, your lordship. My lord, it is regarding a specific relief act, my lord. So, my lord, suit was dismissed. So I filed this CRP, my lord. And what happened, my lord, service is complete. So.
Service is complete.
Yes, sir. Record will be required, my lord. Record will be called for. And it may come in the admission column after receiving the record.
All right. Heard Mr. M.S. Sheikh, learned counsel for the petitioner, also heard Mr.
AK Rai.
A.K. Roy, learned counsel appearing for all the
No, respondent number 8.
respondent number 8. What about other
Regarding
respondents?
other respondents, my lord, case will proceed expeditiously because service of notice is complete. (17/8, 2022) order, my lord.
17/8/2022.
22. Last but one order.
As per the order dated 17/8/2022 passed by this court. Service of notice upon respondent numbers 1 to 7 and 9 to 34 has been deemed to be complete. First of, as such, this matter is ready in reverse service. However, Mr. Sheikh, Mr. Sheikh submits that the LCR will be necessary for final hearing and disposal of the revision petition. First of, registry to therefore requisition the LCR. Let the matter be listed after the LCR. is-
Except respondent number 8, my lord. In respect of other respondents, my lord, case will proceed expeditiously.
That's it.
File your list.
Yes.
May it please, your lordship, my lord, this is an appeal of by the defendant. The suit was filed by the respondent plaintiff on the specific relief act. My contention is this, my lord, in the judgment at page 36. The operative portion, the order passed. It is declared that the plaintiff is entitled to relief of specific performance of contract for such and such. And defending in favor of plaintiff on payment of balance sale consideration of 20 lakhs by the plaintiff to the defendant. Here, the time is not specified as per order 20, rule 12 rate. For that, my lord, the right of section 28 of the specific relief act, my lord, and this is the judgment of this court, my lord.
This is the first appeal.
First appeal.
We'll admit it.
And there is a miscase for stay of that.
Heard Mr. P.K. Rajendra, learned counsel appearing for the appellant. His regular first appeal is directed against the judgment and decree passed by the learned civil judge from our Supreme Court dated 28/2022 in title suit number 13 of 2018, decreeing the suit filed by the respondent plaintiff. I have perused the grounds taken in the memo of appeal and also gone through the improved judgment. Admit the appeal, call for the records, issue notice returnable in 6 weeks. Appellant to take steps for service of notice upon respondent. Let the matter be listed for service of notice.
There is a miscase.
Heard Mr. P.K. Roy Choudhury, learned counsel for the applicant stroke appellant. This IA has been filed with a this IA has been filed under order 41 rule 5 CPC with a prayer to stay the execution of the decree dated 20/8/2022 passed by the learned civil judge, Sonnet Court in title suit number 13 of 2018. I have perused the grounds stated in the IA and also submissions made by Mr. Roy Choudhury. Mr. Issue notice returnable on 21/12/2022. Since 21/12/2022, applicant to take steps for service of notice upon the copy by registered post with AD. Out of the prayer of interim relief as an ad interim measure is hereby provided that execution of the impugned decree shall remain suspended till the return of the date.
My lord, can I pray, my lord, in place of 21, if it is earlier or after 31st?
21 is not, what, no, after 31st not possible.
Then, my lord, before 21,
Before
21. 19, my lord,
19. 19.
Your Lordship, we had filed a caveat application in respect of the instant MSc appeal. However, Your Lordship, neither the caveat has been caveats has been connected, nor our names have been reflected. So Your Lordship may give us an opportunity.
You serve him a copy? No, sir. Heard Mr. K.K. Bhatta, learned counsel appearing to the appellant. Mr.
A.N. Iqbal.
A.N. Iqbal. A.N.
A.N. Your Lordship.
A.N. Iqbal, learned counsel submits that a caveat has been lodged on behalf of the respondents, but no copy of the appeal has been served upon him. Mr. Bhatta to serve copy of the memo of the bill upon Mr. Iqbal. Register to list the matter again in the next week by tagging the caveat with the record of this case.
Oblige, Your Lordship.
By showing the name of learned counsel to both sides. And by showing the name and by or by omitting. Who is appearing? Pass over for the time being.
May I please, Your Lordship? The respondents were supposed to be filing the affidavits
Ladies.
Lord, respondent number 2 is the main party. So far as my affidavit is concerned, I have prepared the affidavit, but I need some clarification from the registry.
What's the matter?
Lordship, regarding fixation of pay,
Fixation,
the petitioners, they are the employees of the principal bench of the High Court. And their pay, when the ROP rules 2017 came into force, their pay was not revised. That is, they, as a result, they have been getting lesser amount of.
Are you
salary.
aware recently about a month back, the government of Assam the cabinet has taken some decision which was notified under the governor's authority. Are you aware of that? You're not aware. Recently, there is some notification.
I'll check, my lord. I'll check. I'm not aware as of now.
Some benefits have been rejected, refused, but some benefits have been given according to
With
which,
regard to that REIT appeal case, yes, my lord. Yes,
how that will
Yes.
impact, check it out.
my lord. Yes.
You are also not aware.
REIT appeal, government order.
Examine it because these are very tricky issues. Sometimes if you succeed in the REIT petition, you may get lesser amount. If you fail, you may get higher amount. That is also possible. Please examine these things. What is to be done today?
Lord, Lordship will grant us some time for filing the affidavit, my lord.
You are for respondent.
I am for respondent number, my lord, High Court, my lord, respondent number 3 and 4, my lord. But main is respondent number 2, because
Who is appearing for respondent?
finance.
One and two, finance and
Three Chelly hai
also
appeared
the
as-
judicial department, Mr. K. Gogoi appeared for the judicial department. It's recorded there in the last order.
Can you call them someone?
Yes, my lord.
Just,
Lord,
just wait, Ms. Burgo.
Yes.
But in this case, my lord, the suit was filed under section 6 of the specific relief act. And we are the defendants. Along with that, they have also filed a my lord, petition under injunction petition. Initially, my lord, interim injunction was granted after hearing the parties' objection and all. My lord, that was vacated. However, parties were directed to maintain status quo. My lord, having dissatisfied that, my lord, they have challenged that order before this honorable court. And this honorable court having found that the principles or the ingredients that to be considered while my lord, considering the my lord, petition under order 39 Lord 1 and 2, those were absent. So therefore, my lord, the order was set aside and it was remanded back for a fresh adjudication. Now, my lord, the fresh adjudication has been made, but my lord, court did not follow or find the existence of the ingredients to my lord, grant injunction or not, my lord. On the basis of a decision of a apex court of 1983, it says the defendant as said to be staying there, they will be staying, and the plaintiff as they earlier were running a school, so they will be allowed to run. So, that is the basic the case. Now, first of all, the earlier order was set aside because the ingredients were absent. The discussion on the ingredients were absent. So the court ought to have considered those ingredients. That was not done. And the case that has been relied on, it was totally on a different footing. There, total land was about 17,000 square feet or so, my lord. And the plaintiff had claimed only possession in respect of 8,000 square feet. So therefore, court said injunction will be only in respect of 8,000.
So trial court has refused injunction.
Trial court initially had refused injunction that was challenged before this court, and this court found that the trial court did not discuss the ingredients, that is the prima facie case, balance of convenience, irreparable loss. So as because those were not considered by the court, the order was set aside and the matter was sent back afresh. So now the same thing has been done without considering those ingredients. The injunction has been granted, and that too, my lord, certain documents have been submitted at a subsequent stage, after
Now injunction has been granted.
granted.
Where is the order? Let us see.
It is at page 113. And lordship may come to my lord, page 116, my lord, the contention of the defendants. Page 116, my lord, about 14th line from bottom, my lord. Has your lordship got it, my lord?
One
Learned
minute, just 1 minute.
Lodge.
So basically a status quo till the disposal of the suit.
No, my lord. The order to the effect, my lord, the conclusion at page 123. Prayer for interim injunction during pendency of the suit is allowed, and the petitioner in the office, their men, agents, servants, and or other claiming through them are restrained from creating any hindrance in the smooth running operation of the Chandra Prabha Hazarika Vocational Institute by the petitioner and the family. The OPs are also restrained from creating any obstruction, hindrance in taking out dumper, etc., belonging to the petitioner's nephew from the suit property and from changing the nature and character of the suit property. The OP number 3, Lavanya Hazarika, is allowed to stay in the suit land, but she is restrained from carrying out any construction activities of creating any third-party interest over the suit property. After fulfilling the above condition, both the parties are directed to maintain status quo until disposal of the suit. This is accordingly disposed of. Here admittedly, in the plain, they have said that they have been disposed on 27/3/2021. It is also admitted that we are in possession of the suit land. So by the
All right, now, Mr. Saikia, you are appearing in this case.
Yeah, I am appearing for the caveat.
All the respondents.
Yes, ma'am. Well, the respondent is a family dispute. Only sole respondent is the other is because order 1 rule 8 represented. They are being represented. So all the respondents, ma'am.
So we'll issue notice and fix it. What order else can be passed today?
the status quo as on today.
No. This is the order of July 2022.
So
wait for another.
I am praying for status quo as on today. As on today. I am not anti. I am not asking.
As on today. Yes, ma'am. My lord, this is an order. With all respect, I will submit, my lord. This appeal has not been filed bona fide, my lord. This is a mala fide, my lord. The order was passed on 8th of July, my lord. They do nothing, my lord. When we file an application for seeking police help only, then only this appeal comes up, my lord. And the area, my lord, is we have been dispossessed from a plot of land measuring about 37 square feet, the 2 bigha, my lord, or 3 katha odd lechas. Now, in that plot of land, my lord, we were operating a school in the name of this vocational training units, Chandraprabha Hazarika Vocational Institute, my lord. Now they have taken forcible possession. They are not allowing it. Before the trial court, my lord, their contention was that this respondent number 3, she doesn't have any place to reside. So it is that will be allowed to, she be allowed to reside. Then we have considered, my lord, okay, let her decide, but at least allow us to operate that school, my lord. Otherwise, it is having a, my lord, public are suffering because they are it is a motor driving school. They are taking training, my lord. So on that ground also, my lord, the honorable court said that, okay, the defendant number 3 be allowed to reside in that, and we will be allowed to operate that vocational training institute. And one of our dumper is also in that premises. They are not allowing us to take out that dumper. They are selling out. And before the trial court, my lord, what happens, my lord, when the matter is put up on each and every date, my lord, application comes out on this or that ground. Because of illness of the counsel or the defendants, they doesn't proceed with the suit, my lord. And when we go after getting this order, my lord, of July, when we went into enter the premises, we were restrained, my lord. Filing no other alternative, we filed an application for police help. Then this appeal has been filed. So my respectful submission is, my lord, this is a plot of land measuring about 37,000 square feet. My learned friend says that status quo be maintained. The already is already there, that status quo be maintained. Allow us to operate that, my lord. Only this limited prayer is that allow us to operate that vocational training institute which was there. Because we and they are also taking, my lord, changing the nature and character of the suit premises. Initially there was an institute. They have removed some desk, bench and all those things. They have removed all the registers and all those documents. And even in their pleadings, my lord, written statement also they have said that on 20 previously they are saying that it was their father's or husband's plot of land. So they are claiming title. My lord, under section 6, my lord, law is very well settled that question of title need not be gone into. So then they come up with a argument that defendant number 3, who is the widow of their deceased father, she doesn't have any place. So we said, okay, let her stay, but allow us to operate and let the suit proceed. Ultimately, if the suit comes to a finding that they have been dispossessed, we have been dispossessed without following due process of law, my lord, law will take its own course, my lord. Now, by my lord granting an order of status quo, what purpose will be served, my lord? We are saying that let status quo be maintained, but at least allow us to run that institute, my lord. We only, my lord, Assam type, there was Assam type 2-3 rooms institute, my lord. So that's the case.
According to them, only on 2021, they have been removed, my lord. They have been dispossessed, my lord. They could not operate it, my lord. And my lord, they have also, my lord, given few photographs, my lord, that again we have the objection where from my lord, it can be shown, my lord.
So
No, we are not going on
what I am
photograph,
submitting,
my
my
lord.
lord, status
My
quo
lord,
as
Your objection to this order that the institution, vocational institution should be allowed to run. Your
Yes, my
objection.
lord, the school does
Then
not
we'll
exist.
issue notice and fix it. That's all.
My lord, the
Or Mr.
status quo as
P.J.
on today,
Saikia,
my lord,
our
I'm
senior
praying for, my
counsel.
lord.
Status quo will be subject to the condition that the vocational institution is allowed to operate.
No, my lord, can you see, my lord, here the suit is for, my lord, specific performance of, my lord, under section 6 of the, my lord.
There is
specifically
already a
from-
status quo order. Why you want another
My
order?
lord, on top of that, my lord, your lordship will see, they'll be allowed to run and operate the, my lord, institute, which does not exist there, my lord. It is a
No, my lord,
contention specific.
from their
and according
document
to-
only, my lord,
according
they
to
have
them also, my lord, it doesn't
submitted
exist.
selective documents, my lord, the document which we have filed along with the plaint, my lord.
How?
There only it was given that permission was given by the DTO to run that institute over that plot of land. Now, once they took possession, they have removed all the registers and everything. Now they are taking a ground that we have not produced registers and all those things. So, my lord, it's a vacant, my lord, plot 2 vega 3 kata land, around 37,000 square feet. Allow us to operate that and institute, my lord, and let the status quo be maintained. Let the suit be decided, my lord. My lord, they have illegally, they have taken the possession of the plot of land, my lord. They will
Therefore,
not.
the suit has been filed, my lord. According to that is their
My lord,
contention, they have been dispossessed, my lord, illegally. So therefore, the suit
no,
has
they
been
will
filed.
dispose us
admittedly-
illegally. They will, whatever, my lord, that it means that a person who is following a law, he approaches the court, my lord, and on each and every ground.
So the matter will require in-depth hearing.
Lordship, hey, any day, my
And
lord,
trial
status
court,
quo
my
as
lord,
on
on
today,
each
they
and
have
every
been
date, my
forbidden
lord,
to
some-
enter into the premises.
Mr. Saikia,
Lordship.
without having a full view of the issue, it will be
Lordship.
difficult to pass that order.
No, my lord, few things, my lord, at a glance I can show, my lord.
If you insist, then I'll consider, but then there is a possibility that the order will be rejected. In which event will it be suitable for your clients? At the
If your
moment,
lordship takes that view, my lord, I have, but then, my lord, here this suit itself is, my lord, for section 6 and it is an admitted on 27/3/2021, my lord. It is more than a year gone by, my lord, they have not been operating there, my lord. And by the order of injunction, what the final relief they have been claiming in the suit, that has been granted. They have been allowed to.
Finally, we are claiming recovery
They
of
have-
one
possession.
minute, just take your, both of you can't argue. Mr. Saikia, what the court is proposing is, since the parties have already appeared, we'll fix a short date, maybe towards the end of November or first part of December, and finish off the entire matter on a non-miscellaneous day. If you are agreeable with that, that order can be
Well,
passed.
Till date, my lord, they are not operating, my lord, and therefore, my lord, they are resisting, my lord, that the status, I am not, my lord, I am not seeking status quo.
Mr.
ante, my lord.
Saikia, you have
I'm-
made your submission,
I'm making.
but the order which was passed by the trial court in the month of July,
Lordship.
on the first day, you want an order which practically allows the appeal.
No,
For that, we have to, there is
not
already
that,
an
my lord.
order of status quo.
No, in between my intervening period, the holidays, everything was there. This was also filed long back.
Then you are-
My only thing is that.
I'm issuing notice on the appeal, and on this, I'll dispose it of today itself. I heard Mr. P.J. Saikia, learned senior counsel assisted by Mr. R.S. Mistral, learned counsel for the appellant. Also heard Mr. A. Das, learned counsel appearing for the respondents on the strength of a caveat. His appeal is directed against the order dated
8/7/2020, page 113, my lord.
8/7,
2022.
8/7/2022, passed by the learned civil judge, Kamal Sibsagar, in Miss Bracket J, bracket close case number 14/2021, arising out of practice of number 10/2021, granting an order of temporary injunction, full stop. Peruse the grounds taken in the memo of appeal, full stop. Also consider the submissions made by learned counsel.
Lordship,
to
may
both
fix in the
the
next
sides.
week, my lord, any non-miscellaneous for hearing, my lord. Next week, my lord, if possible.
No, we'll finally dispose of this IA today itself. Uh, Submissions made by learned counsel to both the sides. Admit the appeal. Since the respondents are already represented by Mr. Das, no formal motion is required to be signed in this case. Upper issue notice returnable on 6/12/2022. Since the respondents are already represented by Mr. Das on the basis of caveat lodged by them, no formal notice is required to be signed in this case. Registry to list this matter again on 6/12/2022 as a fixed item. Yes.
Lord, I take your leave to do my lord, plaint first. Or lordship, my lord, yes, my lord, the plaint, my lord, is at page 18.
So you'll argue the whole matter.
But what I basically wanted to show, my lord, decision admitted that on 27/3/2021, they have been dispossessed. It has been, my lord, admitted there that we are in position, my lord. It is an admitted fact, my lord, that they have, my lord, immediately after the, my lord, 27/3, they had preferred in, my lord, 145 proceeding, though initially, my lord, the attachment order was passed, that was subsequently vacated. My lord. These things are there, my lord. And secondly, my lord, in the written statement, we have said that along with the plaint, they have given as many as 10 documents. It does not show.
So Mr. Saikia,
Lordship, my lord.
you are a very experienced lawyer and a competent lawyer. You will understand this. A stay of this order means allowing the appeal. So this court is definitely not going to stay. The only other way is to dismiss it if you press for it. You argue because what remains in this appeal if this is
I'm
stay.
only praying for status quo as on today. I'm not asking for my status quo ante, my lord,
The
because
status quo would mean that the operation of the institution will again come to a standstill, for which we have to see whole view of the matter, what is the real issue.
and Lordship was saying that they have, my lord, it is stated they have, my lord, submitted application before the police, before the, my lord, court to give the police assistance to enter into the, my lord, the possession of the land. So in between intervening.
All right, Mr.
That proceeding may be.
Status quo subject to the condition that the operation of the vocational institution will not be interfered. That is the order will pass. Mr. P.J. Saikia, learned senior counsel appearing for the assisted by so-and-so appearing for the. You see, you want to stall the operation of the vocational training institution.
It is not there, my lord. It is not there, my lord. It is my.
Then why do you want a status quo
It
order?
was there, my lord, as they have admitted, my lord, they have filed an application to, my lord, assist the.
Then you contest the
for police
application
assistance.
before the court below.
My lord, they
Why
have-
are you
they-
trying to get that thing overreached by a order from this court? You contest it there.
Because I am, my lord, my case is against the, my lord, very, my lord, strong man, my lord, and my lord, MLA of a ruling party, my lord, and in my written statement, I have said no documents are there to show the possession, but we apprehend that they will manufacture some
All right,
documents
you
and
argue.
will submit.
You argue. We'll
And,
hear.
my lord, they have considered some documents, my lord, what I am submitting, they have considered, the trial court has considered some document which were submitted after the High Court's order. The High Court passed the order, my lord, on, my
So
lord,
Saikia, you are taking an undue risk. You want today itself, everything should be done. That looks difficult. Anyway, you argue your case. Whatever you want to argue, I'll hear you as long as you want to argue. Let's fix it at 2 and you argue the whole
can
matter.
be, my lord, hearing, my lord, in the next week or, my lord, some convenient, my lord, early date, my lord, because I am fighting, my lord, my fight is against the mighty one, my lord. And these things is happening, my lord, apparent, my lord, on the hearing day, I'll show, my lord, how the documents have been manufactured and been submitted, my lord, if it can be an early date.
We can have it on 24th November. 24th. Then the appeal itself will dispose it of
On that game, my lord.
24 November. 24 November.
24 November.
In the IA also write so and so to so and so, so and so to so and so. His IA has been filed under order 41-5 CPC with a prayer to stay the operation of the order dated 8/7/2022 passed by the learned civil judge Sipsagar in this case number 14/2021 arising out of title suit number 10/2021. Issue notice returnable on 24/11/2021. Since Mr. Das has appeared and accepted notice on behalf of all the respondents, no formal notice will required to be sent in this case. The prayer for interim order will be considered on the returnable date. It would liখিব, in view of opinion liখিব, in view of the urgency expressed by Mr. Saikia, it is made clear that the appeal will be taken up for final disposal on the next date fixed. Parties to come prepared accordingly. No adjournment on the next day.
Obliged. My lord, only I seek a leave to produce before this court because the documents which we had filed along with the plaint, those documents has not been filed.
Mr. Das, you do whatever you want. He has expressed some concern
My lord,
and the court will definitely consider it.
yes, my lord, we will
The
only.
idea is not to shut him out,
No, my lord.
but the only
What-
point is, on the first day, we cannot decide these
No,
matters
I
without
fully
a
appreciate,
hearing.
my lord. My only prayer is that
If both of you want, we can hear it at 2.
we
or-
are two also, I am ready, my lord. Today also.
Final hearing, disposal.
If my learned friends insist, my lord, I am ready, my lord.
Final hearing, disposal today itself.
I don't have any difficulty.
Because my learned friend is
But I'm not
insisting.
insisting because it is court convenience.
The
is
only
also a
thing
matter
I am
of-
saying is, without having a full view of the
Yes.
matter, I am reluctant to pass any order this way or that way.
That-
That's the point.
Yes.
Because this type of orders create further confusion,
Yes, my lord.
more heartburning. That is the only issue. It's not that the court is not accepting this concern. Therefore, under any circumstances, matter will not be adjourned
Yes, my lord.
on the next day. Whether you want to, if you want to file any document, you file it well in advance
Yes, my
by
lord.
serving copy. Otherwise, we appreciate the urgency of the litigants.
Yeah, my lord. My lord,
They are entitled to an
we also
answer.
appreciate, otherwise, my lord, what happens, my lord, once an order is passed, it is being dragged on, my lord, we wait there till 12:30, my lord, no one is present, my lord. Virtually, we have to send invitation to the other side, then a petition comes for adjournment, my lord. My lord, this is what, and my learned friend says that he is fighting against the mighty, my lord.
He
So
is
this is-
entitled to say what
That
he
is why,
wants.
my lord, this is, my lord, my learned senior is not aware, my lord, what is going on
Yes,
before the
sir,
trial
I
court.
was not the counsel there.
That is,
It is-
so,
Is he not entitled to make his argument?
no, my lord,
Then-
but my lord, I am also, my lord, apprising your lordship, my lord, what is
See,
going on.
the
before the
only
trial.
point is, the court appreciates that either of the party may have extreme urgency in this
Yes, my
matter.
lord.
The reason why I am not inclined to pass an interim order today is that without a full
Yes,
view of the
lordship will
dispute,
decide of the entire matter,
Yes.
my lord.
nothing else.
Not-
It's
yes.
not to defer the matter.
No, my lord.
So there will be no adjournments
On that
granted on the next day. That we are making it very clear.
Yes, ma'am.
He is also answerable to
Yes,
his
my lord.
client.
We also have some urgency because.
Yes, 24th,
20.
fixed item.
Finding letter for admission, item 8.
I apologize, Lordship. I was not there when the matter was called.
Yes, what is this?
Lordship, this is a MSc appeal. We have filed this appeal, Lordship, because apparently the vehicle in which the deceased was traveling, the auto rickshaw, it had a sitting capacity of 3+1. But there were 9 passengers that were traveling in the vehicle at that point of time. Our vehicle is the tractor with which the head-on collision took place with the auto rickshaw, Lordship. But
This
there
appeal
was,
is filed by the insurance company.
yes, Lordship, by the insurance company.
We'll issue notice only at this stage.
Lordship.
Only notice. Hard means C. Mojumdar and counsel for the appellant. This appeal is directed against the judgment and award dated. You have not given the judgment
Lordship, I have-
award dated
Lordship, at page 1.
13/7/2022, passed by the learned member, Motor Accidents Claims Tribunal, Hailakandi, in connection with MSC case number 94 of the 2018. What is the amount awarded? 24,99,000.
Yes, Lordship. 24 lakhs
I
99,000.
have perused the grounds taken in the menu of appeal and also considered the submissions advanced by the learned counsel for appearing for the appellant. Issue notice returnable in 6 weeks. Appellant to take steps for service of notice upon the response by registered.
Much obliged, Lordship.
Item 9.
Yeah,
Mr.
affidavit from-
Gopalari,
affidavit-
Finance Department doesn't care for cases listed.
No,
before
no,
this
my lord,
court.
my lord, with all respect, my lord, today we are, my lord, running sort of manpower, my lord. So that's why my lord, I have been running from
You
court to
need
court.
some, we can give
My
you.
lord, my lord, I will be seeking 4 weeks time, my lord. Perhaps they have not served us with extra copy. I will be seeking a copy from my learned colleague.
Sir.
Seeking a copy.
Actually, what about that latest decision of the cabinet regarding employees of the High Court? Will it have any bearing in this case?
My lord,
Cabinet decision,
that matter is being looked into by my colleague B Gogoi.
it is your internal matter, but that decision.
Some
pertains to the
decision, my
employees.
lord, so far as my knowledge goes, my lord, some decision has been taken, my lord. But as of now,
Please examine it.
We'll
Heard Ms. D. Borgohain.
I
and
will
Council
be
Clerk
filing a
Mr.
counter here, my lord.
Also heard Mr. R. Bapajari, learned SC Finance, appearing for respondent numbers 1 and 2.
Only two.
Appearing for respondent. Heard Mr. K. Gogoi, learned Government Advocate Assam, appearing for respondent number 1. Mr. R. Bapajari, learned Counsel for the respondent number 2. And Mr. H. K. Das, learned SC GHC, appearing for respondent numbers 3 and 4. Who have prayed for 4 weeks further time to seek instruction and file affidavit. Prayer allowed as a last chance. Let this matter be listed again in the second week of January 2023.
My lord.
In the meantime, parties to exchange pleadings, facilitating final hearing and disposal of the writ petition.
I'm so obliged. my lord.
My pleasure, Lordship. In this case, with a new set of lawyers, my lord. On the last occasion, I made an appearance in the condonation petition, which has been condoned, my lord. Our name has not been shown, my lord. So I pray that our name may be shown and list of.
Mr. N.G. Das.
And thus, my.
And thus, like counsels.
And thus, as Sodori and as the Purkas.
He has been recently engaged on behalf of the appellant in this appeal, along with his colleagues, namely.
And thus, as Sodori as the Purkas.
Written the names. Huh?
Can it be listed at
Therefore,
15?
This matter will be listed again after 2 weeks by reflecting their names in the cause list. The registry to take note of the same and do the needful.
May it please the lordship. My lord, in item number 14, your lordship was pleased to allow an IA filed by us on the last occasion, including some private respondents, my lord. That was the order passed on, my lord, 23/9/2022, my lord. And I have taken steps on the private respondents. And today on the office report, my lord, I have checked, my lord, this service awaits. However, my lord, your lordship was also pleased to give me an additional, my lord, way to serve Dusty on the private respondents. But my client, my lord, he is not keeping well, my lord. He is a senior citizen, so he had expressed some difficulties to serve Dusty to whom, my lord, all the private respondents. But he had made a telephonic call to me and have said that some of the respondents have received the notice from this honorable court, but this service report doesn't reflect that, my lord.
Mr. Chaudhary, what is this matter? Those fishery,
Yes, my lord.
your clients would have some urgency, is it?
Our
No,
clients.
they're.
They are the ones. You are fishing
We are fishing.
and they are watching.
So let the service be complete, my lord.
How much time you want? 6 weeks?
No, my lord, not 6 weeks. My lord, as I have been informed that they have received the service in the egg state, this service report will automatically come, my lord, that they may have received the service. In the meanwhile, I can still, it's open for me to take Dusty. If my client is now in a position to serve, my lord, I'll do the Dusty service again, my lord. That is my humble submission.
Then what orders we pass today?
My lord, it has come for orders, my lord, to see whether the service is actually completed or not today.
7 to 11.
7 to 11, my lord.
Heard Mr. H. Buragoy, learned counsel appearing for the petitioner in item 14. Also heard Mr. D.K. Sharma, learned additional senior government advocate Assam appearing for the official respondents. Stop. Mr. M.K. Chaudhary, learned senior counsel assisted by Mr. M. Sharma is present on behalf of the respondent number.
My lord, in the first case, I'm for the respondent number 5. In the second case, respondent number 4.
The respondent number 5. Full stop. From the office note, it appears that service report on respondent number 7 211 is not available. Mr. Borgohain submits that due to some unforeseen health problems, his client, who is a senior citizen, could not effect justice services of notice on the respondent number 7 to 11. However, within 2 weeks from today, the procedure will be completed, whereafter an affidavit will be brought on record. In view of the above and on the request of Mr. Buragohain, let this matter be listed along with item 13 after 2 weeks for necessary orders. Yes.
May I pray for a date not if inconvenient for my lords, may I pray for a date, my lord?
After 2 weeks at a fixed time.
Who
is appearing in item 14?
14, my senior friend, my lord, S. Bhattakur, he's appearing. Mr. Shantanu Bhattakur. S. Bhattakur is appearing.
Any junior present?
Malad, he's Lex in another court, Malad. He's Lex in another court, Malad.
Acha, your name, please?
P. Sinha.
Mr. P. Sinha has appeared for the petitioner in item 30.
I'm deeply obliged.
Obliged.
May I please your lordship? Appeal already admitted lordship. As per direction of the Honorable Court 27/5/2000, only paper publication and a file and affidavit lodged.
Respondent number 2 for service.
Two lordship, two lordship.
And who is for respondent number 1?
Respondent, I am for respondent number 3, your lordship, insurance company.
Acha, who is appearing for respondent number 1?
Respondent number 1, driver lordship.
What about service of notice on respondent number 1?
One lordship may be struck off because of the driver lordship. Very old case lordship.
Heard Mr. K.R. Bora, learned counsel appearing for the appellant. Also heard Mr. H. Buragohain, learned counsel appearing for the respondent number 3. Peruse the affidavit dated 1/10/2022 filed by the appellant, bringing on record the copy of the newspaper within quotes Uttar Banga Samvad unquote of its issue dated 28/2022, wherein notice of this case was published for service upon the respondent number 2 through substituted method. Full stop. First of all, since the publication was made in terms of the order dated 27/5/2022, service of notice upon respondent number 2 is deemed to be complete. First of all, Mr. Bora, K.R. Bora submits that respondent number 1 is the driver of the vehicle, and since there is an insurance policy covering the incident, name of the respondent number 1 be struck off from the array of parties. Full stop. The prayer is not opposed by Mr. Borgohain, learned counsel appearing for the respondent number 3. In view of the above, the name of respondent number 1 is hereby struck off, registered to make necessary endorsement in the cost item. Consequently, this appeal is deemed to be ready as regards service. Let this matter be now listed for final hearing in usual course. Now, final hearing in the first week of December 2022, along with the LCR.
Item 16.
May I please, your lordship? Lordship, in this case, respondent 1 and 2 service is complete, lordship. In for 3 and 4, lordship, as per office note 2/11/22, lordship, respondent 3 has expired 4 years ago, lordship. And for respondent 4, services ID card has not been received. So, lordship, may I place this matter before the local lordship? There is a chance of settlement, lordship. Madam,
Is this matter before?
Local authority.
On the request of learned counsel for both the sides, this matter be posted before the upcoming Lok Adalat, as both sides have indicated that there is a possibility of amicable settlement of the dispute involved in this appeal.
Deeply applied.
17.
May it please your lordship. Lordship, in this case, service on restaurant 1, 2, 3, 4, 5 has been completed. 6 and 7, lordship, they could not be found there. In case not requires a quantum appeal. So 6 driver and owner of 2 vehicles struck off. The appeal has been admitted in any way and 50% has also been deposited.
3, 4, 6 and 7.
Lordship, 6 and 7 only. Because service on 1, 2 has appeared, 3 has filed local number, 4 duly served, and 5 also has appeared. Only 6 and 7 also.
So what is to be done?
6 and 7 will be struck off, lordship. They are not required for examination.
Heard Mr. R. Goswami, learned counsel appearing for the appellant. None has appeared for the respondent number 3. Although the learned counsel, although the name of the learned counsel had been duly reflected in the cause list, Mr. Goswami submits that except the respondent number 6 and 7, all other respondents have been duly served in this case. First of, however, since who is respondent number 6 and 7?
6 and 7, driver of lordship, the bus and owner of the truck, lordship.
However, since the respondent number 6 and 7 are the driver and the owner of the offending vehicle, their presence may be dispensed with.
So there are 2 vehicles. 6 is the driver of 1 bus and 7 is the owner of the other vehicle.
Driver and owner of the 2 vehicles respectively, which were involved in the incident. Mr. Goswami submits that their names be struck off from the arrow of parties. Prayer allowed, registry to make necessary endorsement. First of, office to verify whether the matter is otherwise ready as regards service and list the appeal for final hearing in usual course. Yes.
May it please your lordship. Lordship, as per the office note dated 2/11/22, lordship, the LCI has been received, lordship. And respondent number 1 is appearing, but for respondent number 2, neither AD nor answer notice, lordship. Till date.
Who is respondent number 2?
He is the owner, lordship, owner of the vehicle.
His presence is required. You are for respondent number?
1.
Rupajati Hazarika.
Yes.
Who is he?
He is the claimant. He was the claimant.
Lordship, it is required, lordship, because of ground number B, lordship. Lordship, we will be allowed to take steps through usual process, lordship. Last time we took steps through
On the request of Ms.
Only prayer is that at least 50% amount may be posited so that, because nothing has been paid till date.
Lordship, we did not press the
You are
I.
appearing.
No, I have forgotten.
I have NSAP?
Lordship, then I can go
No,
for
not in this matter. Suppose sir is making some mistake.
item number 18.
Item number 18.
Lordship, we did not press the I on the last occasion, lordship. Lordship,
What is the IA for?
I was for state, lordship. I civil 768 of 80.
And you, this appeal is on what ground? Quantum.
Lordship, not exactly quantum. The respondent number 1 himself was driving the vehicle, lordship. And ground number B, that the claimant was neither the owner of the vehicle nor was he a paid driver of the vehicle, lordship. The policy covers the owner come driver or paid driver, lordship. So, lordship,
There is no stay.
there is no stay, lordship.
There is no stay.
Lordship, anyway, even if there is no stay, but execution proceedings hardly Anyway, your lordship.
Lordship, we can
Because-
take the steps, let it come up in the month of December again, maybe.
Then you file an application. We
Your
can't.
lordship, then that will not be a bar. Pendency of this petition will not be a bar for going with the exhibition. process.
No, she says she's not pressing for the IA. We'll dispose it of. Her in the IA, you write 768 of 2000. Her Miss Chi Mojumdar Learned Counsel for the applicant who submits that she has instructions not to press the IA. Mr. Pushilal, B
Yes,
Pushilal.
B Pushilal.
Learned Counsel is present on behalf of the OP number 1. Since the applicant does not wish to press this IA, the same stands disposed of as not pressed. And in the main appeal, you write, heard Ms. C. Mojumdar, Learned Counsel for the appellant, also heard Mr. B. Pushilal, Learned Counsel appearing for the respondent number 1. On the request of Ms. Mojumdar, the appellant is granted leave to take fresh steps for service of notice upon the respondent number 2, both by registered post with AD as well as by usual process. Full stop. Steps within a week from today, making the same returnable in 4 weeks.
Oblige.
Making the notice returnable in 4 weeks.
Oblige.
May I please, my lord. Service is complete, my lord, in this case. Matter may take for her hearing, my lord.
What is to be done today? Matter is ready as regards service.
Whether LCR has come or not,
Yes.
LCR.
You can't say
Yes.
whether it is ready for service.
LCR has come.
Your lordship, service is complete, my lord.
Okay, who, you are appearing for whom?
I am for the respondent number 2.
Respondent number 2, and who is appeared for respondent number 1?
Some NK Kalita,
Huh?
my lord, NK Kalita. He had filed the wakalatnama perhaps on 26/8/2019.
Your name, please?
M Pandit,
M. Pandit.
yes.
Mr. M. Pandit, Learned Counsel is present on behalf of the appellant. Ms. S. Ray has appeared for the respondent number 2. None has appeared for the respondent number 1, although the name of the counsel is duly reflected in the cause list. Be that as it may, this appeal has already been admitted and the LCR has also been received. Full stop. Since the appeal is ready as regards service, register to list this case for hearing by tagging the LCR.
Much.
Item 20.
Made clear, please, your lordship. The service is complete in respect of respondent number 1, 4, and 5, your lordship. They appear, your lordship, and and as per office note 2/11 of 2022, your lordship. AD got received back and in respect of respondent number 3, your lordship. As regarding respondent number 2, return back and serve, your lordship. And this time might be allowed to serve. This lordship.
So except respondent number 2, others are served. You are appearing for whom?
I'm applying for respondent number 1 and 4.
Respondent 5 also name showing his name.
Hmm?
Respondent number 5 also appeared, your lordship. He is not available now. His name has shown.
Heard Ms. A. Begum, Learned Counsel appearing for the appellant. Also heard Mr. A. Acharya, Learned Counsel representing the respondent numbers 1 and 4. Office note dated 2/11/2022 indicates that service of notice on all the respondents says and except the respondent number 2 is complete in this case. Full stop. Since the notice sent to the respondent number 2 has returned back unserved, the appellant is granted leave to ascertain the current postal address of the said respondent and thereafter take fresh steps for service of notice upon the respondent number 2 by registered post with AD as well as usual process. Steps be taken within 2 weeks from today. Register to verify whether any council has appeared on behalf of respondent numbers 3 and 5 and reflect their name in the cause list accordingly.
May it please your lordship. Your lordship, service is not complete upon respondent one. But your lordship, we had a talk with the claimant's advocate. He said that he will manage an advocate for the respondent number one.
He'll
within a-
manage an advocate.
Yes.
How he'll manage?
Uh,
He'll pay some money from his pocket.
No, your lordship, he will engage counsel.
Who will engage?
The claimant's advocate who represented the claimant in the tribunal.
So who is appearing in this case?
Your lordship, respondent 2 and 3 appeared as per office note dated.
I have for respondent 2 and 3.
2 and 3.
Yes, my lord. Owner and driver. And
And who is respondent number 1?
one is the claimant.
Claimant.
So this notice may issued to have. This notice may be issued
Your
to.
lordship can lease the matter after a week. So that respondent 1 has a chance to.
Heard
appear.
Mr.
They may issue to.
S. Datta, is it?
Yes, sir.
S. Datta, learned counsel appearing for the appellant, also heard Mr. J. Ahmed, learned counsel representing the respondent numbers 2 and 3. None has appeared on behalf of the respondent number 1. From the office note, it appears that service of notice on the respondent number 1. Is not yet complete. Full stop. The appellant is therefore granted leave to ascertain the current postal address of the respondent number 1 and take fresh steps for service of notice upon the said respondent by registered post with AD. By making the notice returnable in 4 weeks. Steps within 2 weeks from today.
Much.
Yes.
My lord, I am appearing on behalf of U Shoikia, Mr. U Shoikia, for respondent number 6.
What about the other respondents?
We have not appeared, also I have not seen the record, whether I have to take step.
Yes, there was an order to take steps. We have not taken steps.
That's it. To this time maybe taken, given also, so that I can take steps.
Mr. KK Bhattal, learned counsel for the appellant submits that due to oversight, steps for service of notice upon the respondents as per order dated 27/1/2021 could not be taken by him, assuring this court that within 3 days, steps will be taken. Mr. Bhatta, prays for adjournment. Full stop. Miss
M. Ahmed.
Ms. M. Ahmed, learned counsel, has appeared on behalf of the respondent number 6 and submits that a wakalat, you filed wakalatnama.
Yes.
A
Yes, ma'am.
wakalatnama has already been presented before this court. Register to verify and list this matter again after 3 weeks with appropriate notice.
Item 23. May please your lordship.
Yes,
As per last office note, lordship, service report is awaited in respect of respondent number 2, lordship. May I pray that lordship, respondent number 2 name may be struck off, lordship. He the driver and owner, lordship. I have filed this appeal for
respondent number
NS
2 is the driver.
driver and owner.
Is both driver and owner.
Yes. I am for only for enhancement, lordship, so his presence is not required. In fact, in the tribunal also, he did not appear, lordship.
Appearing for respondent number 2, insurance company, respondent number 3.
1. 1 we can.
Oh, sorry, respondent number 1,
One.
sorry.
She wants to name of respondent number 2 to be
Yes,
struck off.
lordship.
Whom this?
Heard Ms. P. Bhattacharya, learned counsel appearing for the Appellants also heard Mr. A. Dutta, learned counsel representing the respondent number one stroke insurance company. Ms. Bhattacharya submits that respondent number two is the, no, before that is right. Service report on respondent number two is still awaited. Stop. Ms. Bhattacharya submits that respondent number two is the owner cum driver of the vehicle. And since the appeal is on quantum, his presence would not be necessary. First off. As such, on the request of Ms. Bhattacharya, made with the consent of the other side, the name of the respondent number two is hereby struck off from the array of parties registered to make necessary endorsement. First up, since this appeal has already been admitted and the
HCR is-
HCR has also been received,
Yes.
let this matter be listed for final hearing in the month of December 2022.
Obliged. Item 24.
Yes.
This also Lord Court record has come, Lordship. No one has appeared, Lordship.
This is first listing.
No, Lordship. It is already admitted, Lordship.
Appeal has already been admitted. You have not taken steps.
Lordship. Same
On
thing.
on the request of Mr. Bhatta, KK Bhatta, learned counsel for the appellant, 1 week's further time is granted as last opportunity to the appellant to take steps for serving upon the respondents. Wish the matter accordingly.
Now the
You are appearing for whom?
United India, my lord, that is respondent number
Respondent number one.
one. And also, yes, respondent number one, yes.
But the appellant is not there.
Mr. Agarwala, my lord, he is not there.
None appears for the appellant when the matter is called up. Mr. A. Datta, learned counsel is present on behalf of the respondent number one. Office note dated 12/9/2019 indicates that the respondent number two has entered appearance by engaging a counsel, whereas the name of the respondent number three has been struck off from the record. However, none has appeared for the respondent number two. Be that as it may, since the appellant's counsel is absent today, this matter will be listed again for orders after 4 weeks by reflecting the name of learned counsel for all the parties in the coalition.
28. Make decision, Lordship.
Yes.
Lordship, actually, yesterday, Mr. D Das, who is the appellant in the main appeal, Lordship, he called up that he will be taking time in this matter because it's unwell. Lordship, do not know.
You are appearing for?
And for the respondent insurance company, Lordship, we have also filed a cross objection. Because we said that they'll be taking time, I did not bring the brief. with
Ms.
me, Lordship.
C. Majumdar, learned counsel is present on behalf of the insurance company. None has appeared for the appellant. In view of the above, this matter stands adjourned for 6 weeks.
Achha, yes, sir.
May it please your lordship, Your lordship, actually the counsel appearing in this matter could not come. So I crave leave of this honorable court to appear as petitioner in person. And since it is a very limited matter, so I thought it's prudent to go ahead with the matter. Your lordship, this is a review petition which has arisen out of the final order and judgment dated 29/11/2019 passed by this honorable court in FAO 30 of 2019 along with an IA which was filed by the opposite party, whereby this honorable court was pleased to dispose of the aforementioned appeal and the temporary injunction by holding that the impugned order dated 13/5/2019 passed by the learned trial court does not call for any interference from this honorable court. Your lordship, actually, if your lordship wants, I can give a small bird eye view of the matter, or I can just proceed with my prayer in this.
Yes.
Yes, so your lordship might recall it is a dispute which was between a brother-in-law and a sister-in-law with respect to certain properties, and the and hospital. So with respect to certain inadvertent errors apparent on the face of the record, but since a lot of time has passed and the matter is proceeded in the trial court, I do not wish to press with respect to the errors apparent on the face of record. But there is certain inadvertent clerical errors or typographical errors which might have taken place while typing the order, which needs, in my humble submission, needs to be rectified in the interest of justice. So if I can take your lordship to page 12 of my review petition. These dates are actually very critical in the entire matter. So page 12.
So has notice been issued to the other side?
No, your lordship. Notice has not been issued.
Notice first.
Yes, your lordship.
Miss
P. Barua.
Miss P. Barua is present in person on behalf of the review petitioner. Heard submissions advanced by petitioner in person. Also peruse the grounds taken in the review petition. Issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondent by registered post with AD within a week from today.
Obliged, your lordship.
May it please your lordship. As per office note dated 31/10/2022, affidavit regarding paper publication of notice upon respondent 2 has been received and kept at flag P. And your lordship, LCR not received.
How many respondents are there?
3 respondents, your lordship. Your lordship, respondent 3 has been struck off as per order dated 18/8/2021. And your lordship, respondent 1's service complete as per office note dated 4/3.
Respondent 1 has been served.
Yes, your lordship, as per office note dated 4/3/2022.
Heard Mr. S. Dr. Learned Counsel for the appellant. Peruse the affidavit dated 23/6/2022 filed by the appellant, bringing on record a copy of the English daily newspaper within course, the Assam Tribune, of its issue dated 21/6/2022, wherein legal notice. This in the newspaper notice was to be published for service on whom?
Respondent number 2.
Then why you have written respondent number 1 in the affidavit?
Your lordship, there was some mistake, typographical mistake perhaps.
It will be difficult. For service of notice upon respondent number 2 whose substituted method. It appears that the notice was published in the newspaper in terms of the order dated Which order of the court? Nothing is written. This is so poorly managed.
Your lordship, for the last order, the latest one.
As per the order dated 23/5/2022 passed by this court. In view of the above, service of notice upon response number 2 is deemed to be complete. The name, the notice in this case has already been served upon response number 1, and the name of the response number 2. Response number 3 has already been struck off. As such, this matter is deemed to be ready as regards service. LCR has not been received.
No, your.
Office to issue reminder for LCR and list the matter thereafter for necessary orders.
Much of it. May I please, your lordship? Lordship, as per office note dated 31/10/2022, lordship. Respondent number 4. No ID card has been received. That upon respondent number 4 and 5, lordship, till now. Then lordship, I will take fresh step, lordship.
You are appearing for whom?
Respondent number 1.
1. What about 2 and 3? What about 2 and 3?
2 and 3, lordship. 2, lordship. The claimant, lordship, and 3 is the driver, lordship.
Your name, please.
A.K. Das on behalf of M. Khan, lordship.
Heard Mr. A.K. Das, learned counsel appearing for the appellate. Also heard Mr. V.K. Borua, learned counsel representing the respondent number 1. On the request of Mr. Das, leave is granted to the appellant to take fresh steps for service of notice upon respondent numbers 4 and 5 by registered post with AD. The names of respondent numbers 2 and 3 have already been struck off from the array of parties. Steps within a week, then names of.
My lord, the condonation matter is pending, my lord, the IA civil 261/2021, my lord. There is a delay of 24 days, my lord. And the claimant has entered appearance for the respondent number 1.
Who has entered appearance?
Mr. F.A. Hassan has been reflected in the conference. And from office note dated.
All right,
7/9.
Mr. A. Datta, learned counsel for the applicant. None has appeared for the respondent number 1, although the name of the counsel is shown in the cause list. Office note indicates that service of notice upon respondent number 2 and 3 is also complete.
My lord, the both have expired, my lord, the office note 6. Your lordship will kindly see it.
Office note dated
7/9.
It appears that no legal error, no substitution. is required.
No, because one is the husband of the claimant. Wrongly, it was made a party in this case by me. And the other person has died during the pendency of the proceedings.
Substitution is not required.
You know,
It appears that the respondent numbers 2 and 3 have already expired. Is there any substitution?
in fact, to my knowledge, I have to,
Mr.
I have
Dr.
to
Six,
take it from
4
Mr.
weeks
Hassan.
time to obtain instruction as to whether any substitution of the legal aids is required in this, of the deceased respondents is required in this case. And if so, file appropriate application.
Because the 2 is owner, my lord, and the policy is.
Prayer allowed, let the matter be listed accordingly.
34.
May I please your lordship? Lordship, my senior is out of station. Let the matter pass over for the day.
What is this case? What is this
I
matter?
responded to lordship.
This matter is respondent
Respondent 1357.
on the prayer of learned counsel for applicant, these matters still adjourned for 4 weeks. Yes. Mr. K. Suleiman.
J.M. Sulaiman.
J.M. Suleiman is present on behalf of all the respondents,
Of lordship, all the respondent.
on behalf of the respondents. Yes.
Please, lordship. My lord, I'm the applicant actually, I'm the rest. Now the file then, respond number 1 file and application. Mr. A.R. Agarwal is appeared. So my lord, he is absent. His IA number 380 of 2022 for paying for proceeding appropriate order.
You are for the insurance company.
I am the insurance
None
company.
appears for the applicant when the matter is called up. Mr. R.C. Pal, learned counsel is present on behalf of the appellant of the opposite party insurance company. Since the applicant's counsel is absent today, this matter stands adjourned for 4 weeks.
Much
Yes.
May it please your lordship.
Hmm.
This petition is for refund of statutory amount of rupees 25,000, your lordship. MSC appeal number 564 of
What has
2007.
happened? Appeal has been disposed of.
Yes, your lordship, as per order 4/2/2020.
Let's see, let's see. Heard Mr. S. Dr. Learned Counsel for the applicant. This IA has been filed with a prayer to permit refund of this security. As a statutory deposit of rupees 25,000 made by the applicant stroke insurance company at the time of presenting the appeal. First, Mr. Datta submits that by order dated by the judgment and order dated 4/2/2020 passed by the learned single judge in MSC appeal number 564/2017. The appeal has already been disposed of by modifying the judgment and order passed by the learned MSCT, Kamrup. As such, the insurance company be permitted to seek refund of the statutory deposit. First off, after going through the materials available on record and also after hearing the submission of applicant's counsel, this court finds no justifiable ground to deny the prayer made by the applicant. As such, this IA stands allowed. The applicant is permitted to approach the registry for seeking refund of this statutory deposit of rupees 25,000. IA stands disposed of.
Much.
Similar prayer also for direction to the registry to refund the statutory deposit.
Heard Mr. R. Goswami, learned counsel for the applicant, stroke insurance company. This, give it a file, in the file. This IA has been filed with a prayer to permit the applicant to withdraw the this IA has been filed with a prayer for refund of the statutory deposit of rupees 25,000 made by the applicant at the time of presenting the connected appeal. First of Mr. Goswami submits that by the judgment dated 2/2/2022 passed by the learned single judge in MAC APP number 229/2016, the connected appeal has been disposed of. As such, the insurance company be permitted to withdraw the statutory deposit. Full stop. After hearing the submission of learned counsel for the applicant and on going through the materials available on record, this court does not find any justifiable ground to deny the prayer made by the applicant. Full stop. As such, the applicant is hereby permitted to seek refund of the statutory deposit of rupees 25,000. Full stop. Registry to do the needful, highest and disposed of.
Item 42.
I'm the appellant in this case. The respondents had filed one IA for releasing of some amount for which we will be filing an objection, Lordship. Because in this case, there is an issue of driving license. So 2 weeks time will be given, Lordship.
You see, right, none appears for the applicant. Mr.
SP Sharma, Lordship, for appellant.
Mr. SB Sharma, learned counsel for the appellant stroke opposite party, prays for and is granted 2 weeks time for filing objection opposing the prayer made in the IA. This the matter accordingly.
Item 44.
May it please your lordship. This IA is for condonation of delay, your lordship. There is a delay of 29 days.
Now, Mr. S. Dr. Learned counsel appearing for the applicant, his IA has been filed under section 5 of the Limitations Act 1963, praying for condoning the delay of 29 days in filing the connected appeal. Full stop. Issue notice returnable in 6 weeks, calling upon the respondent to show cause as to why the delay should not be condoned. Applicant to take steps for service of notice upon the sole respondent by registered post with AD, as well as usual process. Stop. Steps within a week.
45.
Yes.
These are similar matter for condonation of delay of 29 days. Filing the connection.
Mr. BK
Regular
of
first
29 days. And rest will be said. Address, notice.
Item 46. Item 46.
Who is appearing? None appears for the applicant on call. Contestants pass over.
Item
For
47.
the day.
Lordship, on the e-court service website, Lordship, it is shown that the matter has been disposed of on 15/5/19 by the lower court below. Matter has been disposed by the lower court below, Lordship. On 15/5/19.
Acha, the original matter.
Lordship.
Then this will become infraction.
Lordship.
Mr. B. Chakraborty, learned counsel for the petitioner submits that during the pendency of this transfer petition, the original proceeding has been disposed of by the trial court. As such, the matter has become infractious. Stop. Taking note of the submission of Mr. Chakraborty, this transfer petition stands disposed of as infractious. Interim order passed earlier shall stand vacated.
Item 48.
May it pleases, my lord. My lord, as per the last order dated 10/8/2022, my lord, lower court records were called for, that has come, my lord. So, my lord, the matter is ready regarding service, my lord, so let it come for admission here.
As per the order dated 21/12/2021, this honorable court has passed an order for admission and for final disposal. So the matter may be fixed for admission for.
Heard Mr. A. Iqbal, learned counsel appearing for the petitioner, also heard Mr.
M. Kalita.
M. Kalita, learned counsel appearing for the respondent. So stop. It is submitted at the bar that this matter is ready at the service and the LCR has also been received. In view of the above and on the request of learned counsel for both the sides, this matter is directed to be posted for admission hearing along with the LCR in the first week of December 2022 as a fixed item.
Interim order passed.
Interim order passed earlier to continue till then.
Highly your best.
Hello, best.
Lordship, may it pleases. Lordship, my order, my prayer for amendment of the WS was rejected, dear Lordship. Once it was allowed, again, they have preferred on CRP that was again, it was sent back and it was rejected, dear Lordship, that I have challenged. Since the LC has been received, your Lordship may fix the matter for admission in the coming week or after 1 week, Monday.
Yes. When do you want it?
First week of December or
We can have it earlier, 17th November.
Lordship,
17th
yes,
November.
my lord.
yes.
Pardon me, we are learning senior counsel assisted by Ms.
B. Bora.
E. Bora, learning counsel for the petitioner, also heard Mr. P.S. Decker, learning senior counsel assisted by Mr. P.K. Bhagavati, learning counsel appearing for the respondent. It is submitted at the bar that this matter is ready as regards service and the LCR
Scan copy has been
and
received.
the scanned copy of the LCR has also been received. Considering the urgency involved in this matter, the learned counsel for both the sides have paid for posting this case on 17/11/2022 for admission hearing and final disposal. They are allowed register to release this case on 17/11/2022 as a fixed item.
Lordship, interim order may continue.
It is necessary interim order passed earlier to continue till the next stage.
Argue matters, I can do 5, 6, 7, 8, 9, 10, 11, 12, 15, 17, 18, 19, 20.
Anybody ready? Part two, both sides?
My item is item number 6, my lord. Other side is.
Then we'll take it up on Monday. You tell him.
Yes, my lord.
You inform him.